Alexis, thanks so much for being with us this hour. All right, we're listening to the sergeant on the stand, the lead detective in this case, and he's reviewing a lot of the evidence, surveillance footage, also in particular what he was just talking about, showing Swilley's his wagon, dump truck, taking it, going to a dump area. And I know some people have said in this case that, you know, this isn't maybe unusual for him to maybe go to a dump site, but it seems suspicious.
It definitely seems suspicious, but if he was a handyman, I mean, it wouldn't be highly unusual for him to go to the dump, probably on a regular basis, you know, depending on the situation. Although it's not great because we do have this video that appears to him going to the dump, along with the testimony with the timeline, because, you know, it's not suspicious that somebody wakes up and goes on the internet either. But the fact the phone was off, you could argue he was asleep. But this timeline that's been provided does raise some questions.
Oh, yeah, a lot of questions. And the more that we see this evidence, I'm curious your thoughts on this, Alexis, because you're there in Florida, so you know some of the different lesser charges that there could be in a case like this. First degree is what he is charged with. But I was wondering about why, with all of this evidence that's against him, there isn't the argument of something like self-defense, something like I was defending myself or we got in a fight, I didn't mean it, it was, anger. We've seen that in some other trials and it's actually worked. One of them, Dr. Ingolf Turk, that we covered not too long ago, he argued he choked his wife to death, buried her in a pond, put rocks in her pockets, but ultimately he said, I didn't mean to do it, and the jury gave him something lesser. Do you think this defense should have gone a different way other than I didn't do it?
I don't know. I mean, that's obviously a strategic decision that's made with the attorney and the client as to how you're going to approach it. I think that there's they had the second house. It wasn't unusual for them to spend time with other people. And if that's the case, somebody else could have potentially have done this. So I think that's what they're going to stick with, and we'll see what the jury thinks.
Alexis, okay, defense counsel's getting into, something here, possibly saying this could be Jordan. And it really does make you think about it. Who had access to the victim in this case? Well, the daughter did, and the defendant. And on cross-examination, he's asking him why didn't he investigate the daughter further?
You're right, Kelly. And boy, was he fired up. He was definitely fired up. I think that he's doing his job. He is presenting, hoping to present reasonable doubt that it could have been someone other than the defendant. And these are valid points when you're asking the police officer, what did they get out of the information? And, bringing up the point that he didn't hide that he went to the dump. So I think that it was an effective cross-examination.
Effective cross. I like how you said fiery, because I was concerned about I don't want to just call them theatrics, but the tone, of the way that he was really going after this defendant, or detective rather. Sometimes that can turn off the jury when attorneys get that way. What did you make of that?
I think it was a little loud, and it was almost teetering over to that he was yelling at the witness. And you are correct that some jurors will find this to be offensive, and it won't align with them. But I think it was reflecting the passion, and for you to really believe and think about that there may be some questions here that haven't been answered.